everybody. First of all, thank you so much for the introduction. Also, thanks for attending the last panel. I know there was amazing speakers all day today, so hopefully this will be, you'll get some takeaways from this, and this panel is not to scare you, but just, kind of like get you to thinking about kind of what the moving landscape is looking like in the context of developer liability. If you were here yesterday, then you know I like a good theme. It was a plumbing theme. And today we have like a ship, wreckage, hurricane, water theme. So get your life jackets, OK? With that, I forgot I had a clicker, so I can just do this. Have to put my disclaimer on as an attorney. So this is not legal advice. This is an as-is presentation. I actually also will disclaim that I had to amend this presentation because, which I'm sure many of you in the room can appreciate, like the industry is just changing so rapidly, and it's hard to keep up. And I created this presentation about 2 weeks ago, and I found it out of date. So I had to amend it accordingly because there had been some new movements where it just really fit and aligns with the discussion for today. So with that, I'm going to start kind of just giving a high-level, broad overview of the changing tides from a legal landscape. So we'll start with the EU AI Act. I'm sure everyone has heard of it, is aware of it. It's the first AI regulation, comprehensive AI regulation in the world. It addresses what high-risk AI systems look like, prohibited risk, and has some requirements for developers to adhere to, right, by doing certain types of assessments, accountability, and transparency. From the US perspective, everyone thinks that we don't have any regulation, especially with the new administration who took a kind of like a deregulation approach, at least from an AI perspective. Although the federal government is internally still regulating AI pretty robustly. So it's an interesting juxtaposition, but not the topic for today. With the states, they've kind of like left it up to themselves. Many states have enacted or have proposed AI laws. And some states have now taken a position to propose developer liability. Rhode Island is an example of one who's flirted with this idea, but that has it wound up dying in the committee, so it never passed. I'm not sure if it'll revamp maybe next year, but I'm just signaling this because states are thinking about developer liability, and that's just an interesting topic and issue, especially around like AI, and of course, I'm sure as developers, or most people here are developers, so you're probably concerned about that. With other states, for example, there was California, who just as of September 29th, the governor signed the Transparency in Frontier AI Act. What does that mean? It basically sets out developer requirements to publish governance frameworks, establish mechanisms for reporting critical safety incidents to the California Office of Emergency. So similar to like breach incident response, this is AI incidents. They're not necessarily tied to security incidents, but there could be crossovers there. I imagine that the critical incidents probably relate to public health, national security, or other threats of that kind. And it also offers some whistleblower protections, among other things, just at a high level. So then we also have other states like Colorado, who had passed their AI law in May of 2024, and it goes into effect in February, and that also puts some requirements on the developers, so they need to conduct a risk assessment, similar to the EU, right? So it's a lot of the similarities, at least in the United States. There's some mirrors to some of the requirements in the EU AI Act. And more recently, which is kind of the whole reason why I needed to amend this presentation, was that surprisingly, there's a bipartisan bill that was proposed a week ago in the Senate and that is called the LEAD Act. And what does that do? That basically is a bill that introduced like developer liability for AI. So just out of curiosity, like how many people are developers or are working with AI technology or okay? Oh, goody. This is perfect for you then. Awesome. I'm glad that I hope you can find this, at least educational and something to take away from that. So essentially, like this is, I mean, first of all, it's bipartisan, so that's amazing that there is some agreement, I guess, in the states. So they introduced this bill that creates developer liability where the developer will be liable if they failure to exercise reasonable care for product development and product design, which I'll go into in a little bit and actually have a use case for that as well. It also outlines, among other things, like failure to provide proper warnings, adequate safeguards, product warranty failures. There's even some language in the bill where developers can't really they can't contract with a deployer and kind of carve out their liability in that contract. So that was pretty interesting as well, just to kind of go through. So that's kind of what's going on, at least from like the state's perspective. And I think just taking a step back from a global perspective, there are various laws, not just in the EU, in LATAM as well, APAC, and obviously the US, where they are creating more responsibilities for the developers if they're creating AI. So I think that's pretty significant because now, instead of just being creative and making something, there's a lot more responsibility and lots of different requirements from a legal perspective, and now there's other risks around potential developer liability issues. So I'm actually going to talk a little bit into this, some of the court shifts as well in the US, though that's really limited. And I think I'm disclaiming, I'm not sure where the court's going to go, but we can see there's some patterns that are happening, at least in the US, with respect to product liability and entertaining this thought of strict liability. Which I can get into. Just out of curiosity, how many people are familiar with strict liability, the concept of strict liability? Okay, so I'll go over that. I just didn't want to go into it too much in case people were kind of aware of that. So strict liability basically essentially holds a person or an organization accountable for the harms or injuries that are created from or what they create or from a product without any regard of whether there was any intent to cause harm. So it doesn't matter. With negligence theories, it's usually measured about with the standard of care. Courts will look to see what precedent case law or what the industry standard of care is. And specific sectors might have different standards for sure about what that standard of care looks like. So negligence is kind of what was the reasonable, did you do enough to safeguard this product, to put the enhancements and security protections in place? Whereas strict liability, it doesn't matter if you did it, it happens and you're liable. It's usually in the context where the product is inherently dangerous. So if you're lighting fireworks, that would be a good example. So it's kind of interesting right now that the court is, like I said, flirting with this idea with products liability and strict liability theories as it relates to AI products. So let's dive into that a little bit more. This is just a high level slide about the types of risks and liability, and we're just really going to be focusing on the upstream liability here. So the storm warning. So here's some of the telltale signs where there's going to be a shift probably in developer liability, although I could be wrong, but I mentioned earlier the AI LEAD Act. which was introduced by the, that was a typo, September 29th, not 19th. So sorry about that. So September 29th, 2025. There is developer requirements I mentioned earlier with that high-level overview of what the legal landscape looks like that are making developers go extra mile to demonstrate, show their work that there are proper safeguards, AI governance, transparency, accountability, all of that in place. And now I'm really going to talk about this case right here, Garcia versus Character Technologies. So interestingly, this is a sad case. This child was 14 years old. He committed suicide after signing up for an account with Character AI, which is a chatbot that you can create your own avatars, basically, and it could be like any person you want. In this instance, they used the child used Danny from Game of Thrones. I don't watch Game of Thrones, but if I'm saying it wrong, but Danny, that character. And so Danny was this character that unfortunately the child was interacting with and wound up committing suicide. So I'm bringing this up because this is the first, to my knowledge, this is one of the first AI applications or technologies where the court is now entertaining with this like strict liability theory. And I do want to kind of just like pause and just make sure I clarify and explain that some of the laws that are existing or proposed around developer liability, that's not necessarily that they're proposing strict liability. They're just proposing developer liability in the context of like negligence. So like, are developers doing everything that they can do to avoid harm from a particular app or product that is being developed? Whereas strict liability in this case is a legal theory which now the court is entertaining. Traditionally speaking, the courts don't treat applications, software, code, or anything like that as strictly liable. So it's kind of interesting that they just ruled on this matter back in May. So essentially, defendants said, no, you can't do this because this is an AI product, and this is software. This is not a product. You can't make any claims of product liability, essentially, to sum it up. And then the court said, no. Actually, they've met X, Y, and Z, and specifically, I'll just read a few of the lines here. So, right. So I said that the courts typically don't extend liability to words or pictures or code or things of that nature, but here they have found, or at least in Florida apparently has found that certain aspects of the product could potentially be found, like you could go under like the strict liability theories. So before, I'm going to talk about this slide, but just some like little anecdotes from the judge's words here. Essentially, the strict liability theory, it's not on necessarily like the code source. It's basically like the outputs of what the technology is doing. In this instance, there wasn't any like warning signs. Even there's issues because they were a minor at the time when they signed up, so there's a whole lot of like legal issues on that regard. But then also there were no like safeguards in place for the responses that the Danny chat person was saying to the 14-year-old. So it's not necessarily the underlying code. It's like, how is that code being then implemented and deployed, and what are the outputs and the functions of the product that is now up for potential strict liability considerations. So that's kind of where I want to just draw that distinction. And so where are some of the gray areas and kind of that uncharted territory where this is all hypothetical, but here's in some instances where I could potentially see where a court might find even like the source code, or if, for example, if an employer is, if there's a company who funds or they employ a person or like a team of people who are maintaining different source codes, or if they like expressly warrant that the code is AI safe, or making some kind of like statements around the code specifically, because that could potentially make express warranties claims. So that's kind of where I could see potentially. And also, this is happening all in real life right now, so I'm not sure if this is the way it's going to go. I'm just saying there are arguments or potential arguments that I could see where perhaps a court could kind of dive into that and dig a little deeper. With this particular case, this is really early on, and I just want to also highlight that not only was the Character Technologies company named in the complaint, but also the individual developers and also the funded company. This is a Google funded, Google was implicated in this, and that's a whole other mess in itself. But essentially, they're asserting claims because another company essentially like funded this other company to develop this particular product. So they are also asserting or trying to hold that like Google or this other company accountability here. So, and it's actually the same. There's another lawsuit that was filed. I think I put it on the screen, but I couldn't bring it up because it's just the complaint and there hasn't been any ruling on the complaint yet. But this is Rain versus OpenAI. This was another situation in the US where a child committed suicide because they were, seeking, I guess, they were seeking AI for therapy, and so there was not a lot of safeguards, or that's what the complaint is saying. So essentially, the complaint, I read the complaint. The complaint is kind of mirrors this one here with the same types of allegations. They're still asserting like developer liability, negligence, and also the strict liability. So the court in Florida allowed this to proceed. So that doesn't mean that any types of the defendants here are found guilty. It's just now it's still in the process of being heard in the court. I'm not sure if this is going to go to trial. If I had to guess, it would probably settle. But it would be interesting to see if this could go to trial, just to see how people would find that, and just also to create precedent. Because again, like a lot of lawyers like myself, this is all new, right? This is very, very uncharted territories, just as much for us, just that it is for you in trying to navigate all of this. So I think that's, let's see. Oh yeah, we talked about the gray areas, and here's where I kind of just outlined where I could potentially see the threshold. So it's not at the open source, right? I think I made that clear, like at least in this complaint, it's not saying the open source, but it is saying like the implementation of the product. And I have no idea if this is based on open source, but I'm just saying, like, generally speaking, like in the context, like if open source is being used to develop some kind of AI product, then these are things that you need to consider and consult with an attorney as well. So, so what are some things that you can do as developers to, and I have like 5 minutes less. Let me see if I can, hopefully I can get this all in. So what are some things that you can do to try to prepare yourself and just to make sure that you can avoid these types of negligence claims, and do the best that you could do to protect yourself and your company and your product? This is something I kind of put together. This is not by, but after reading some of like the new Senate bill, and obviously some other laws, just kind of like thinking about, and also having kind of worked with developers and startups in the AI space, talking them through about, especially if they're like working with children, or they're product will be used by minors, thinking about like these like the worst case scenarios and like how to respond. So kind of taking like a incident response approach, but like tailoring it to like your own code and your own like product development. What kind of like user notifications can you like trigger or can be triggered? Is there like a kill switch? For example, a client that I work with, they have kind of like chatbot features, and they are used in schools. So what kind of, so things that potentially, you know, in various different discussions to consider, you know, I was like talking through like, is there ways that you can kill switch? Or is there any ways that you can identify where like a student or when someone is misusing the technology in a way that kind of creates that red flags, right? So in like laws where they're like the banking laws, for example, have like red flags where there's like a kind of like suspicious activity, nefarious or criminal activity, kind of like a similar situation, but in this context, it would be creating like red flags for when the product is being misused in a way that could harm a person, others, or just like generally like the public. So I don't know necessarily what that kind of response code could look like for your own. It will probably look very different depending on the industry you're in, what the type of AI you're building, because not all like AI that you're building is going to be used maybe by like people. Maybe it's just it's for threat intelligence, right? So it really is dependent on what the use is, what like who's the audience, who is it intended to be. And so I think for here also just some kind of just like checks, like when you're developing any types of application, whether it's like using AI or not, but these are some steps that you should consider. Always making sure that your like license hygiene is good, you have your disclaimers, and you know, connect with whoever your lawyer may be or counsel, because there's a lot of regulations now out, especially in the EU AI, with the EU AI Act. If you know, most people here are in the EU territory, but in the US as well, if you ever decide to work in the US or have your products in that location, there's a lot of legal hoops to jump through as well, even though I know the stereotype is that we don't have any, but again, so definitely just like connecting and get counseling on like what do these legal risks looks like. So, and I highlighted this particular case, this matter, just so you know it's there, it's out there, it's being entertained, and these are just risks that you need to consider. Oh my God, less than 1 minute. So sorry. Does anyone have any questions?
Thank you so much for this excellent and equally frightening talk.
Sorry.
Questions? Well, I'm willing to entertain one question. Raise your hand, get the microphone towards the back.
I have two. First of all, that Florida case, that was like the lowest
yeah, it's at the district court.
So it was not, it went through the appellate court, so we will see how it goes.
Yeah.
And the second one is, did the court suggested some kind of proportionality test, like you are more liable if you are going closer to the minors or something like that?
So, okay, the first question was the court, was this case in like the lower court? Yes, it's a district court. It's a district court, and it still has to make its way. I think the second question, if I heard that correctly, did the court do any type of what was the last part again? Analysis on? Oh.
Closer we are getting to the minors and AI.
They didn't do that, and that's not something the U.S. court would do. That's a standard that would eventually go to like a jury. But in this case, they just evaluated the claims that were being made. So at least in the U.S., like the plaintiff has like the plaintiff has the bar to demonstrate that the defendant committed X, Y, and Z kind of wrongs, and they have to assert various claims. So here, the court entertained the claims. They're like, yep, you met the checkbox for all of the claims asserted here, with the exception of one, but it's not related, so I didn't bring it up. But But essentially, it's just kind of this is like a very early stages. The only reason why I brought it up because this is new. This is kind of like a big new a new complaint that's going forward, at least under strict liability theory, which is why I just highlighted that. But again, to your point, it's at the very low threshold right now. So I guess we'll see what happens moving forward, or not, because they might settle. But in any event, it was just to the purpose to highlight that the courts are at least entertaining these theories now, whereas they were not. Like, applications and software are always considered as not considered under strict liability.
Thank you so much. Unfortunately, we are running out of time. I'm pretty sure Ashley will stay around in case you want to have another free consultation. But let's give a very nice round of applause. Thank you so much.